Hello, everybody. This is Focus on Oil and Gas. It's episode number 2 of the Financial Poise Chapter 11 Industry Focus 2024 webinar series. We're going to cover a lot of material today, so put on your seatbelts. I'm going to go ahead and share my screen, and you will be able to see the slides as we discuss them. And our panelists today are Scott Cockram. Scott's a financial and restructuring advisor who knows oil and gas and corporate restructuring. Mike Deba. Mike's also a corporate restructuring professional who also has a deep experience in the oil and gas space. And JP Dick, John Dick. JP is a consulting petroleum engineer, an expert witness who also knows his way around bankruptcy quite well. My name is Jonathan Friedland. I'm the moderator. Slide 5 contains a disclaimer. You're not our clients. We're not your retained advisors. What we do here today is for your general edification, not for you to act on without appropriate advice from someone you're paying. Slide 32, and you'll see what I'm doing here. I'm turning to slide. I'm trying to multitask and turn to the different slides as I refer to them. Slide 32 begins our bios. Financial Poise doesn't permit us to do infomercials. I'm not going to tell you, 30 seconds about each of us. Instead, you're going to have to be impressed enough with us to take a look at the bio starting on slide 32. Let's see. If you're listening but not watching the webinar, you'll be just fine, because this really is a conversation. The slides sit in the background. But if you choose to consume it on demand, you'll get more out of it if you follow along. The webinars are supported by sponsors. The sponsors are, and I'm turning to those slides now. On slide 3, Hello Mood, the world's largest online cannabis dispensary. Slide 4 speaks of Sunburst Digital, maker of Type to Learn, the #1 typing app for students. And it speaks to Max Assets. It's a turnkey online auction platform used by professionals in the corporate distress insolvency space. Slides 3 and 4, again, for those sponsors. Slide 37 is it's the last promotional slide. It's a slide advertising 2 treatises that anyone involved in the corporate restructuring insolvency space should probably own. I'm a little bit biased. I'm involved in those. And finally, slides 36 and 38 they mention the producer. Daily DAC LLC is the parent of Financial Poise webinars, as well as the National Law Review. And you can see a little bit more about Daily DAC and the tools it provides to restructuring insolvency professionals on slide 36, and slide 38 tells you more about Financial Poise and Financial Poise webinars. Okay, that's the administrative stuff, the housekeeping. We can now dive into the substance. And to do that, I'm going to start with slide 11. Slide 11 presents sort of a broad, bird's eye view of the industry. The webinar is intended mostly for Chapter 11 professionals who are experienced generally in Chapter 11, like me, that's what I am, but who are not terribly experienced with oil and gas cases, again, like me, or the industry. So slide 11, as you can see, suggests that the industry can be divided into 4 basic buckets: upstream, midstream, downstream, and oil field services. My understanding is that the term midstream is broad and encompasses various activities, including transportation, storage, processing. Scott, tell us more about the midstream. Audience slides 19 through 21.
Thanks, Jonathan. So when we look at the midstream and we look in general about what function they're performing, the broad thing to keep in mind is that if the analog is that upstream are farmers who are renting access to their farmland with a finite depleting resource, midstream is the conduit to get hydrocarbons into processing and eventually the retail market. And the way, and that includes the whole barrel of oil, all the different byproducts and ingredients that come off of it. So because of that, and because it's not like a utility, but it's providing a service similar to a utility, midstream has a whole host of agreements, and it's not looking for a ton of subsidies in order to go ahead and or the largesse of a sovereignty in order to provide that access. Usually what midstream does is they provide the plumbing from the wellhead to downstream in order to ensure that those hydrocarbons get where they need to go. And so in order to do that, they ramp up and utilize multi-year contracts. You can call them, gathering or storage or processing agreement, all those other different facets of getting hydrocarbons to market. Midstream, that whole sector can accomplish that. The initial capex in order to set up those lines or storage, or even stripper plants for rudimentary processing before it goes to true refining, those are usually borne by the operators up front with a little bit of capital investment, but by and large, it's done with the operators, and it's locked in quite a long term in advance. Because of that, that can lead to problems for those operators and those players in the marketplace when the market turns against them. They have force majeure. They have offset operators who are drilling, next to their assets and their existing wells, and so all of that is effectively up for grabs in how we look at the health of a company. We can talk a little bit later about contracts and how they either run with the land or not, and how they're severed from the existing assets that tie into midstream. But think of it as plumbing, and think of it as enormous contracts with associated hedging that can truly determine the profitability of a company depending upon market conditions.
Okay, so that's an overview of midstream. I'm going to stick with you and ask you next about downstream. But before I do, I want to see if Mike or JP want to overlay onto your explanation about midstream. Either of you guys?
No, that was a really good explanation.
Very good.
Okay.
Thanks, guys.
No more of that. We don't get to congratulate each other every time. Good answer. Good answer. Okay, fine. We agree it's a good answer. We'll indeed reward you with the next question. Segue into downstream for us, Scott.
Look, downstream, the retail portion of it is what everyone sees everywhere they go, driving a vehicle, and that is fine. The refining is really the piece that could affect oil and gas players more than anything else. And if we wanted to talk specifically about downstream and how they're affected by distress and restructuring and bankruptcies, we certainly could. Bottom line is there's a lot of diversification, a lot of vertical integration, in refining. So how it affects a lot of independent players, and keep in mind, there's over 5,000 independent oil and gas operators in this country. There are more independent operators than Taco Bell's in the US. So when we talk about the diaspora of different operators and how they're getting their product to market, refining in and of itself is the processing of those hydrocarbons to get them into something that is usable for the end market. However, there's all sorts of factors that affect their throughput, whether it's geopolitical risk in Europe or in other parts of the world, whether it's maintenance or force majeure from storms or all sorts of other different activities or regulatory changes that affect the market. The backlog there can flow back through to independent operators who are most at risk to have an issue occur that puts them in a restructuring situation. But by and large, by the time we get to the downstream space, it's pretty much plug and play, and it's pretty much designed to be continuous throughput in order to get oil and gas and their constituent byproducts to the consumer everywhere.
Okay, overlay, guys. Move
Yeah.
on. Oh, go ahead, JP.
One comment is on the refineries. There's not that many refineries. So one or two goes offline, it affects prices exponentially, I will say. The 5,000 operators are your gas stations and stuff. But the refineries are very limited.
And when you refer to refineries, you're not talking about, you're not talking about a company, you're talking about a specific physical facility, I take it.
Correct.
Okay.
The facility that can take the oil and turn it into the gasoline, whatever products are needed.
Right. What does that leave in our boxes? Upstream.
I think we talked about upstream. I think oilfield services is probably the only one that we
Oh,
have.
right. Oil field services.
Yeah, the way to think about oilfield services is it's actually a really broad category. It's everything from remediation on the surface in order to allow access to drilling contractors, to hydraulic fracturing, to compression, to tool fishing, I mean, you name it. There's a whole industry meant to support E&P activity. And so the key thing to think about oilfield service companies is they're not reliant upon a recurring revenue stream the way operators are, or midstream players are, or even downstream players. And so because of that, they're sort of at will for the industry. They may have a contract for a drilling program that gives them 6 months, 8 months, 2 years worth of runway, but there are also outs periodically and from a capital perspective for oilfield services. It's also not asset intensive from the perspective of I could buy a frac fleet for however many millions of dollars, but at the end of the day, I have a very limited market in which to move those assets. Yes, they're absolutely portable. Almost all of it's on wheels. I can take it from the Appalachia if it's not, if the Marcellus play is not doing, or the basin is not performing as well, or I'm not getting the utilization I want, I can go down to the Permian, or I can go hit the DJ Basin. I can move those assets, but by and large, I don't have, the NOLV, the net orderly liquidation value of those assets is not great. And so because of that, when we talk about oilfield services, and I've worked a few of these in bankruptcy, and we talk about how they sort of work in a turnaround market, they're the first to get hurt and they're the last to recover. And so you'll see larger players that sort of go through consolidation waves, but for the most part, they really are beholden to what's happening at the top end of the value chain with E&P, and it flows through to them and they get hurt first.
Simple question probably for you, but when you use the term operator, does that term refer to a player in only one of the specific 4 buckets of the industry?
Yeah, I'm always talking about upstream. Personally,
You're always talking
about an operator. That's right.
Let's look at slide 12 together, and we'll use this as a talking point for JP. JP, I'll ask you the question, pretty broad question. What causes an oil and gas company to have to file bankruptcy?
For the operators and the upstream side, typically it's where you've been levered, so you can go do some activities and drilling completions, and all of a sudden prices change, drop, whether it's oil or gas, depending on the area. So if you're all built up at $90 a barrel and it goes to 50, and you're levered up, you're upside down when it reserves. And prices for commodity changes, drastically for the last 50 years. So that's what I see. And then on the service side, they're driven by the activity of the operators. So if the operators aren't drilling, if they're not completing, if they're not doing what they're doing, then all of a sudden you've got fleets being stacked, you've got yards being closed. They're either moving to a more active area, or they're in a bind there.
Okay. Guys, do either of you want to overlay on what JP just told us? Causes of distress. Moving on then, Mike, take out your crystal ball. when are oil and gas bankruptcy lawyers gonna get busier?
They're gonna get busier in 2015. Because in 2014, we were having $90 a barrel of oil, and in 2015, it turned to $48 a barrel within about 45 days. So if you can tell me what the price of oil is going to be at December 31 of this year, I can tell you how busy the bankruptcy lawyers are going to be. So basically, it all depends on what the price is, and not only oil. Everybody looks at oil prices. It's also gas prices too, because a significant portion of these companies are gas. So when gas doesn't recover, and gas has been low for quite a while, it will very much affect your cash flow and your ability to pay your debts.
To state the obvious, when we talk about gas during this webinar, we don't mean gasoline, we mean natural gas.
Yes,
Yeah.
natural gas.
Yep. Does anyone want to take a more crystal ballish approach to my question about taking out a crystal ball?
I might add that it's also going to be very regional. So if it's natural gas prices are hurting, it's going to hit the natural gas producing regions. Eastern Oklahoma, Pennsylvania, different areas where it's predominantly natural gas. Whereas if oil suffers, then you're looking at areas like the Permian, Delaware, Powder River, Bakken, Western Oklahoma, things of that nature. So it can be very regional in its effects depending on which product at what time.
Don't we have big pipelines under the ground to make our markets so that they're not regional? That's not a thing. Remember, I come with no context. I'm a bankruptcy lawyer.
Typically, most companies some are balanced. The big majors are more balanced, but you're talking about a lot of companies who are all in on natural gas, maybe in the Marcellus, maybe in the Haynesville in East Texas and Louisiana, or maybe they're more oil prone and being in the Bakken. Unless you're a major, you typically don't have a 50-50 mix. So even though it's all about prices, so it's all about revenues and income.
Okay. Sounds like your business, the industry's a betting man's sport.
You have to have a glass half full mentality, that's for sure.
Yeah, it's a cowboy culture too, right? I mean, at the end of the day, if you're incentivized to go ahead and get institutional capital and take a piece of acreage and put a drilling program to work, you could easily have two that break even and the third could do well, and that could set you up for life. The rewards are immense, but because it's a depleting reserve, you sort of take these chunks and make these bets. And we've seen a lot of consolidation. You go back to 2014 or 2010, or you can go all the way back through all these different downturns that have hit the industry. And we find more and more companies start to improve their balance sheet, reduce their leverage. There's consolidation with more diversified players. And so by and large, you see sort of the sea change trying to get to a more stable industry, but the underlying commodity is extremely volatile. You can go back to April 20th, I believe, of 2020, when the cost of carriage went negative. Oil and gas, there's no
I had clients who actually had to pay to sell their oil.
That's right. That's right.
So now I'm gonna put more of a bankruptcy lawyer pair of glasses on, if you will. I'm gonna start asking you guys to address some questions in a context that makes more sense to me. And you'll see what I'm talking about in a second. First category, what comes first in a free fall, non-pre-pack, well, any case, I guess, first day motions, right? That's a thing for any Chapter 11 case of size, first day motions. So given the unique attributes of the sector, of the oil and gas sector, are there specific concerns or considerations when preparing first day motions that you can summarize for us? Mike, this question is for you.
Yeah, in a first day motion, in the free fall, or when a company files, and we have, of course, our pre-petition and our post-petition. But we have to understand what the operator does, and the operator is the one that either is drilling the well, or they go out and they're operating the well. And in operating the well, they will collect the revenues from the oil and gas, and they will distribute it out. In order to be an operator, you have to have licenses and state approval, things like that. Believe it or not, oil and gas is a regulated environment in which we live in. So like on first day motions, things you would not see in a normal Chapter 11 are one of the very first day motions is to make sure that the surety bonds get paid. Even if they're pre-petition, going post-petition, you got to have a surety bond to operate. The other ones you will see is hedging agreements. So the hedging agreements takes out part of the bet. So it's just your insurance on the bet. When at the very first of 2016, going back to 15 is a great example. When we had the free fall from the 90s down to the 40s, a lot of people cashed out their hedgings, even to the point that some of the hedging companies were having a difficult time paying up. We generally go in and get a super priority for the administrative expenses to do post-petition hedging agreements. So in bankruptcy, we're doing those too. 3 or 4 other things is, remember, the operator has to make these payments is mineral payments, royalty payments, working interest disbursements, and joint interest billings to bill those. So those are first day motions you normally won't see. And just think of it as you have $1 of revenue coming in, 12 cents of that dollar will go to the royalty owners, which we'll talk about later, or those creditors or not, or is the royalty payments property of the estate. But that's the royalty payments. A working interest owner is if Scott was drilling a well and I invested in that well, then I would be a working interest owner. I get part of the revenues, but I have to continue paying the LOEs, which are the lease operating costs. Those are the joint interest billings. So I would get billed, I have to pay that, or the well doesn't operate. So all those kind of first day motions are the things you see in an oil and gas case you do not see in most other cases.
Since you mentioned the royalty owner, let's go ahead and talk about in not in the context of first day motions, but certainly in the context of the first days of a bankruptcy case. If I'm a royalty owner and I see my counterparty files for bankruptcy, what should I do?
Pull out the first day motion if there is one on royalty owners. The question is, once again, are royalties a property of the estate or not? Filing a claim. You don't want to file an unsecured claim because it's really not an unsecured claim you have. That is your money, and a royalty exists because the operator or the or the company drilling will come to me and lease my land, and not the surface, but the minerals underneath. And in that lease, I get the 12% or a percentage as a royalty. So it has nothing to do with operations or anything else. I don't have to pay any bills to get my royalty. And so it's a, by situation or by case, if those royalties get paid or not.
Yeah.
Overlay, guys?
I would, and Mike summed up really well. The thing I would add is if you're a royalty interest holder and the operator files, the first requirement, hire an attorney immediately. Like, do not wait. This is not an arena in which you want to try to parse what a bankruptcy judge is going to do, because they have, and a lot of folks on this call will understand the power that they have in cases like this. More often than not, venue selection is such that they look for a complex case. Even for a small operator, it's going to be a complex case, and get an experienced enough judge to be able to handle it. But I have seen in cases where royalties are mistreated, not paid. Same thing goes for other LOE, lease operating expenses, that are not properly paid, that are incurred post petition, and there's very little recourse for those royalty holders as the case drags on and gets closer to confirmation. You know as well as I do, Jonathan, you get on the 2-yard line and you're about to get a plan confirmed, and any hiccup like that is probably not going to go for 100 cents on the dollar. So just judicious tracking of everything that you're supposed to be paid is crucial, because you just run the risk of not being paid what you're owed in normal course as someone who gets a first day motion to ensure you are paid in full.
Before I leave first day motions as a topic, I'll just ask the open-ended question. Anything else, any other operational issues impact the first day process that you can think of that are worth articulating in our limited time? Anyone?
A lot of those first day filings are similar to other industries. A lot of them are.
The critical vendors, if you're a natural gas, predominantly natural gas company, your critical vendors are going to be your compressor companies and things like that. So the critical vendor list really needs to be scrubbed down on the first day motions to make sure they get paid. Because if they turn those off, you're not in business very long at all.
Okay.
Yeah.
All right, let's move on to the financing and cash management context. And JP, I'll ask you this question to start. Are there particular challenges or strategies for obtaining DIP financing in this industry? Audience, slides 13 and 14.
It's predominantly based on your reserves and your cash flows. We're seeing some banks go more on a cash flow basis than we are on a reserve basis, but the basis for most lending in the industry is based on the reserves, and your reserves can vary based on the pricing. Again, I go back to pricing all the time because it's so critical. Your reserves are, because your expenses typically are very fixed. Even the variable expenses vary based on production, but your fixed prices are what they are. So at some point, you could have reserves go up and down 20 to 30% based on pricing year to year. Unproved reserves, future drilling, typically financing is only based on the producing assets and maybe a little wink and a nod to some of your undeveloped assets, even if they're proved and improved in the legal sense. In my industry, is a 90% confidence in the wells being able to produce and I'd be identified. But again, a lot of the undeveloped locations are based on future timing, which is depending on future pricing. So most of lending and reserve is reserve based on what's producing already.
What about cash management practices? Do they differ for an oil or gas company in a Chapter 11 compared to other industries?
Yeah, there's a lot of nuance there in the 13 week as you build it out, right? It's usually buy well.
Yep.
So we have, companies that we work that have hundreds of thousands of wells onshore that are part of their inventory. So ideally you want to go buy well. You also want to ensure, just like we talk about that waterfall, that all of your royalty interest owners are getting paid, that you can break out as appropriate all of your OpEx to ensure that you can keep things running. But then JP's talked about this too, right? You have CapEx associated with drilling. And we'll get to that, I think, further down the line in our conversation. But the ability to sort of manage that CapEx and all the appropriate taxes that come with it, it is nuanced, it is industry specific. It really does require knowledge and experience in the industry. I wouldn't grab someone who came off of a consumer products case and expect them to be able to step in. They'd just be a fish out of water, and it would be exposed very quickly for not covering all of the appropriate cash flows for the debtor.
Overlay, guys?
Yeah, I will add that when we talk about royalties, there are people we know or in the royalty pool or the royalty owners. There are people that have been identified that you can pay them. There's other sections of land. You take 160 acres and let's just, I'll just go back to Oklahoma. You go back to Oklahoma and ownership might have changed 30 times since the land run. And so you don't know who the owners are. So the royalty, you have to hold that money, or you're supposed to hold that money. Generally at the time of bankruptcy, those accounts are depleted, so there is no money. But post petition, you'd better hold that money because it's an administrative expense, as we all know, post petition, and it's not your money. It's not the debtor's money. It's somebody else's money.
One thing I might add is in a lot of cases, the royalty owners are paid separately by the purchasers of the oil and gas and not by the operating company itself. But it puts that company, they're the ones that are paying back the working interest owners and the royalty owners. And when they hear of bankruptcy, all of a sudden they just stop, they lock everything up. So sometimes the money don't go back to the operator to pay out the royalty interest owners and the override royalty interest owners. It is distributed from the purchaser, the gas pipelines, the oil or gatherers, and refineries. So revenues to these people come from different places, not only the operator that's maybe going through bankruptcy.
Right, and the term you're looking for here is suspense. Anytime you see suspense, something's not being paid out, and somebody's holding what's not paid out, just make sure there's assets to back up that suspense.
Okay. Anything on this topic before I move us on? Next topic I would like you to cover is that of executory contracts. And let's start off, Scott, this will go to you, audience. We're going to go to slides 17 and 18. Can a Chapter 11 debtor assume or reject an oil or gas lease the same way it can any other executory contract or unexpired lease?
The easy answer is it depends. Depends on the state, right? A lot of these are state law dependent. And then it's funny, this is such a volatile industry. We keep coming back to that point, right? That there's a lot of outs for an E&P company, regardless of whether or not they're in or out of Chapter 11. Until I go ahead and produce in order to hold a lease, there are all sorts of different outs, and they're all unique, right? For the rights holder to claw back the lease for non-performance, either for time or for production value or amount. There's an opportunity for an operator to abandon the lease. There's all sorts of different things that can be done in order to effectively sever that contract. So when we get into bankruptcy, not much really changes. If anything, you're now in a cash strapped position as a debtor where you may say there's just no way I can effectively produce these. It is an asset. Can I go ahead and sell them? And there are provisions that are lease dependent and state dependent on whether or not you could go ahead and even transfer that in a sale or some sort of a transaction. So the leases themselves they're not valueless, but they are at a much reduced value compared to when you actually get production on them. And then you've HBP, you've held by production those leases. And then we get to a point where, okay, I know we can talk about this now if you'd like. We can talk about effectively how we can take any producing asset and we can slice it into a whole host of different working interests. And that's for the operator of record as well as non-operating working interest holders. And when we start to split out all of these different people and we look at a drilling program per se, we have the opportunity in or out of bankruptcy to say, if I am not the operator of record and the operator of record wants to go ahead and drill a well, I'm cash strapped as a debtor in a process. Almost always there's an option called a non-consent option, in which case that non-operating producer then says, or working interest holder says, no, I'm out. I cry uncle. And there's a whole host of lease specific or area of mutual interest, effectively just something drawn on a map that says these are the assets that we own or we have access to and are exploiting. And you say, all right, fine. There's all sorts of different mechanisms there once we get to that part of a program, right? And so the actual contracts and whether or not you're going to have to participate, it really becomes more of a cash management issue than anything else. And you can go to the specific language of the contracts. Very, very rarely would I say that an operator is being compelled to go ahead and drill something based upon a contract, and as such, they would want to reject that in a bankruptcy. You almost never get to that point. I'll defer to the other gentlemen on the panel for if they feel differently, but usually you've got quite a few outs there.
Before we go on though, you use some nomenclature, some proper nouns that I don't understand because I'm not in the industry. One of them was HPB.
Yeah, held by production. Effectively, I've drilled the asset. I have now gone ahead and satisfied the lease's requirements in order to place that lease and that well onto into a set a set paradigm through which I will take out the hydrocarbons. I will pay you, the royalty owner, and we will do that throughout a lifetime that is prescribed by a contract for a specific depth and a specific target formation.
You're saying as a producer, I've got obligations under my contracts with my royalty owners. I've got to do certain things by certain times.
That's right.
In terms of drilling and extracting. And as long as I do that, I get to keep my contract. But if I don't meet certain requirements, I could lose it. Am I saying that kind of right?
Yeah, that's right. You surrender the contract at that point, and
Okay.
I've seen 3, 5, 7-year leases. 7's rare, but you have longer term leases that if you don't drill within that period of time, you relinquish the right to go ahead and explore for assets.
Okay. And you used another term, I think, owner of record.
Yeah, if you're the operator of record, you're the person who's
Operator of
responsible for
record.
the conduct of the actual operations there, and you are you're responsible for making decisions. We could talk for hours about different responsibilities and liabilities that are held by your partners, but the operator record, at the end of the day, there's one general saying charge. That's the operator record for a well.
And I thought I heard you also say, are there operators not of record? Or is that a thing?
yes, you could have non-operating interest holders who are not the operator of record, but they may be, depending upon what you've hammered out in your operating agreement, who may have responsibilities. It's fairly rare. Usually the operator of record handles the vast majority of that, but you got to go back a ways, I think, to see more of that happening. JP probably has forgotten more about that than I would know.
Well, also you're going to have some entities that may be non-operators that are a shell or a holding company for a whole bunch of other interest owners. You may have a group of 50 guys investing through one entity, who's a non-operator that owns 10% total, and the operator has 50% or 30 or 50 or 60%. Operator typically has over 50%, but there's no prescribed interest ownership that they have to be the operator.
Yep, that's right. A lot of alternative investors will go through that route, and more often than not, what they don't want to have happen, an alternative investor does not want to hold the majority of the economic interest, right? They don't want to hold the majority of the interest and have the operator of record be, 25, 30, 40%, because at that point they feel that they've exposed themselves to some liability through the conduct of the economic life of the well.
As I'm thinking broadly about the topic of executory contracts, what else? I asked you specifically about oil and gas leases. What other types of executory contracts, if I was smarter on the subject, would I be asking you about?
I think your offtake agreements, right? Anything that has to do with your requirement to fulfill a supply contract. An offtake agreement is a supply contract in any other industry, right? So I have agreed to supply you, the counterparty, with so many barrels of oil, so many million cubic feet of natural gas, or NGL, natural gas liquids. Effectively, I've agreed to supply you. And it used to be, before the Sabine case, and Quicksilver was another one, where those midstream contracts used to be tied to the wells, but now we have more than enough case law to actually look at the ability to sever those. And the requirements of those contracts are onerous, as I've said before, and your ability to reject those and sever them from their associated wells gives you an opportunity as a debtor to really restructure your company and its cash flows upon emergence. It truly has given debtors a lot more power than they used to have in this arena.
You compared an offtake agreement in the context of an oil and gas case to what a moment ago?
Like any other type of supply agreement in another industry.
And is it a supply agreement that has an element of you must take all I produce?
Usually it's, well, they all differ. And so what I will say is, more often than not, there's a volumetric threshold, and there are pricing tiers. There's also a hedging element, not just for your reserve-based lending, but also for your offtake. And so because of that, they're extremely complicated, and you may have periods where you underproduce, in which case you more often than not have to pay the delta between what you're beholden to provide and what you actually provide, or an offset depending upon what it is. Like I said, there's the NGLs, oil and gas are three common offtake components. There's also, if you overproduce, you sometimes get metered or get paid at a different rate than your volumetric requirement. And there are sometimes where the midstream party, your counterparty, cannot take in excess of what you're providing. So it really is sort of a dog's breakfast of all these different elements that go into what each and every agreement between each and every provider, to say nothing of the actual locations where these are occurring as well. Onshore, offshore, in the US, outside of the US, there are a whole host of considerations here. And I will say that normally in a case, we will take one professional and just say, I'll see you in a couple of weeks, start going through all these contracts. They're that complex and they're enormous.
Another thing is and I'll bring this up again. You'll hear the same words out of my mouth because, as you said, Jonathan, this is kind of a bet on things, and I don't bet. So the hedging contracts. And the hedging contracts are, to me, extremely important. You don't want one to lapse. You don't want a hiccup in it, because the last thing you want your premium back or your fee back when you have a flip of very high contract and the prices are very, very low. And I know JP and I have had 2 or 3 cases where the hedging contracts have actually confirmed the plan. So
The slides 25 and 26 audience speak to hedging transactions, but before we go there, I happen to be displaying a slide called joint operating agreements. Have we already talked about the concepts on this slide? You're muted, Scott. Dumb that down for me and the audience. What is that slide? What are the most important things that slide conveys about joint operating agreements?
It's the rules of the road between how the operator of record is going to go ahead and carry out a drilling program. Sometimes with an AMI, sometimes not. Sometimes they speak to specific drilling locations, but it is
AMI?
Area of mutual interest. It's like I said before, it's an area drawn on a map. So more often than not, it is literally your contract for how you're going to go ahead and operate. I mean,
It's my, if I'm the producer, I'm the driller, who is my joint operating, who's the counterparty of my joint operating agreement?
all your other working interest holders. More often than not, it's your investors.
Okay.
And it covers a specific area so if it's a certain section, like you're in Oklahoma, or a certain unit, if you're in Texas, and essentially there's different models, different years, different things have been stricken, changed, modified over the years. So, 56 is going to be different than an 82, and it's going to be different than a 96 version. So you have to kind of get knowledgeable about, and they're fairly similar, but they're, as times have changed in the industry, so have the joint operating agreements. And then you have to go into now pooling agreements where in Oklahoma and other states where they're forced pooling, where they're kind of going around the joint operating agreement side, and there's a pooling that you do at the regulatory commission that pools the interests to allow you to drill wells on a certain acreage. And they're kind of a bastardized similarity to the joint operating agreement, but aren't joint operating agreements or regulatory agreements.
So leaving the pooling agreement aside for a moment, I want to ask you if I understand the following concept correctly. If I'm and let me go back to the slide. Hold on a second. I'm in the upstream business. I'm exploring, I'm drilling. And I've got a contract. This is a question. I've got an oil or gas lease with whoever owns the land. And then on the other side of me, I've got a joint operating agreement with my investors and maybe others. Is that right?
Yes.
Oh.
Yep.
Okay.
You nailed it. You're ready to be an expert in a case.
How about that?
Yeah, and it dictates how much you can charge for overhead. It dictates how much, what kind of operations you have to advise your interest owners as to when you do a workover. It has to exceed a certain amount. After a certain amount, you have to get approval from a certain number. It also advises if you want to get changed out of operations, you can get kicked out of being the operator if you maybe have 30%. And 60% of the people say they don't like you anymore. It gives the rules of the road, as Scott said, to operate a given area and the wells that are within that area.
So if I've got a joint operating agreement, my understanding based on listening to you guys, and it could be wrong, but that's my fault, not yours if it is that my joint operating agreement can be with a number of parties, and some of those parties may just be my economic investors, my financial backers, but other parties might include other operators. True or false?
No, there'll be one operator for that joint operating agreement for that given set of area. And
So
you may
if
have
I-
50 other interest owners that have anywhere from 1/10% to 50%, but you're the operator, so you're the named operator under the JOA. So you have the authority to make decisions.
Am I the named operator because I'm the one who comes to the table in privity with the owner, because I've got the oil and gas lease?
Typically because you're the majority owner in that area.
And you said that the counterparties could kick me out as the operator if they're unhappy with me.
Yes,
And if they kick me out, do they have to go look for another party that's a skilled operator, or is there probably a skilled operator among those parties?
typically there's going to be one amongst the parties, but yeah, it's not that common
Okay.
because
JP,
typically you have to have over 50% to kick somebody out, and typically the operator has over 50%. But in today's time, when the normal horizontal well costs between $9 and $13 million, and to be able to have a robust program, you don't take 100% or 80% of every well anymore. Most companies don't, unless you're a public company. Some of these private companies have 5, 10, 15% and a whole bunch of those, and they still may be the operator because they were the moving party who got the thing started, but they don't have a majority of the interest.
Okay.
A lot more common now.
So
Yeah, and just the last thing to add to that is you talked about other operators who might technically be, that's usually just their consideration for contributing something, whether it's capital or more often than not, it's acreage that was thrown in to be operated.
Thank you.
That's what puts them in that mix. And I probably should have been clear when I talked about that before.
That's helpful. I'm here to make sure that you guys dumb things down. Slides 25 and 26, as I mentioned earlier, talk about hedging. And we really should get into that a little bit. So we're running out of time though. So give us, the 90-second version or less, JP. How are you going to summarize hedging transactions in this context?
In this case, hedging transactions is a financial instrument where that companies typically, when they go get loans, they get levered. The banks, the financial institutions are requiring you to at least hedge out the gas price so they can guarantee their payment to the banks for a certain period of time, 6 months, a year, year and a half, 2 years. So those are financial instruments that that lock in your gas price, which is good when it's $100 a barrel. You can lock in for a couple of years. So even if prices go down, you're cleared until your hedges roll off. But like Mike said earlier, that sometimes is the most valuable asset you have if prices do go down. So it's very important, and it can be a very important part of any bankruptcy of a company's assets at any given point in time.
So I think if you explain that well, what I heard was that hedging is hedging, and I'm familiar as the bankruptcy lawyer. I know hedging in other contexts. It doesn't seem that different in this context.
No.
All right. Now we may move on. And now we will talk a little bit about asset sales under 363, because they happen in oil and gas cases just like they happen outside of oil and gas. Mike Diva, tell us a little bit about how 363 sales are typically structured, because I understand from our pre-conversations, as we prep for this webinar together, that there is sort of a little bit of a typicality in how asset sales are structured in this industry. Go.
yes, they are. They're structured in a 363 sale in an oil and gas case is like Professor Bombay when he asked Thornton Mellon the 2 questions with 48 parts to it. it all
What
depends.
cultural reference is that?
It all depends. Back to school, of course.
Okay.
It all depends completely on what the circumstance is. I have been involved in, seen 363 sales where they've sold the whole enterprise, the whole oil and gas company. We've talked about the JOAs, the leases, things like that. I've also seen it piecemealed on 363s that you will sell a lease or you will sell and one thing just to make sure that I mention it on a lease, there's basically two types. There's an operating lease where you have a well on it or a well's been drilled and it's a producing lease or one that hasn't been produced. So you could sell producing in one at one time or the non-producing. It also is, as I said, well by well. I've seen these 363s where we go in and we sell well by well or sections of wells. Or if you're the operator, we talked about the operator. If I have 60%, I'm the operator and I own 60% of the well or that, I may just buy that portion of that lease or that well and not the others. So once again, in the 363, it goes by lease, because remember, you're buying, when you buy the well, you're really buying the lease or you're buying the JOA. And rarely do I see a whole enterprise being sold in a 363. You're not buying the whole company. Okay. So generally in your smaller cases, you're seeing it being pieced out, lease by lease, well by well.
Overlay, guys?
Yeah, the thing I'd add is most of these companies, aside from the producing assets, there really is not much value. You could have a 3,000 barrel a day company with 12 people. There's just not a whole lot of assets besides. So you want to get down to the actual producing wells to affect the sale.
Plugging and abandonment, slides 23 and 24. What does that mean?
That is real quick. ARO or asset retirement obligations, plugging and abandonment. And your plugging and abandonment is think of it because it is an environmental liability. It may stick with the company, it may stick with the previous company, and it may stick with the buyer. And so that is whenever a well goes dry or you have to come in and plug and abandon it. Each state has their own rules, the feds have their own rules, and you have to reserve for the plugging and abandonment.
So go ahead, I'm sorry.
You just don't move off of the land after you've produced something. You've got to go in and make sure that it's cleaned up, that you've taken all of the oil, all the contaminants out of there, and then plug that well.
So I raise plugging abandonment in the context of maybe being a concern from a buyer's perspective, slides 23 and 24, and that's true. But it's also true that it's by no means only the concern of a buyer. If you're going to confirm a plan, that's an issue that's got to be dealt with.
Yes,
I
because
could have brought it up in the plan context as well.
yeah, in the plan context, if you don't have the funds or if you're not planning for the plugging and abandonment, it's not feasible because you have to plug and abandon.
The costs offshore are far higher than onshore. And on April 15th, BOEM, the Bureau of Ocean Energy Management, they're the regulator for offshore. They introduced a rule that will require a much larger liability reserve. A lot of that is accomplished through bonding, but it is an increased cost and it makes transactions that occur in a court or a plan confirmation in a court for offshore players to be much more of an issue.
We're really just about out of time, but before we end, you guys know generally where we were gonna go in terms of what my next questions would have been. So take a minute, if you would. What topic didn't we cover that we really would be remiss if we didn't at least make a mention of it? Who wants to go first? Don't be shy.
I'll go first. Claims and creditor issues. Okay. The claims and creditor issues we see in a normal bankruptcy are a lot different sometimes. We have the normal ones, but they are different, as we've mentioned, with royalties, with leases, are you working interest owner, and things like that. It is, I would always look to the claims and the waterfall and what your standing is in each case. And as Scott said, first thing you do is you hire an attorney or the claim holder needs to hire the attorney to come in and say, what are my rights? What class do you fall in?
Does anyone want to follow suit with a different subject?
Sure. As someone who has to normally do evaluation for a debtor, either as debtor's advisor or for the lenders or for the UCC, I will tell you that in and of itself has its own level of gamesmanship that is far more heightened in oil and gas than in other industries where I've worked. And so your ability to look at the strip, look at consensus, look at estimates from different groups like the Society of Professional Engineers or Petroleum Engineers, excuse me, and all these other different expert groups, and try to take that confluence in order to map out what the value of the company is really something that requires professional to do. And it's a large part of sort of seeing where claims get paid out and all the different classes of claims get paid out for a plan is confirmed.
Great. Any last issues by anyone? Going once, going twice. Thank you. Thank you, panelists. This webinar is concluded. Thanks for coming, audience.